Welcome to this presentation by the EPA Alumni Association Academy. Before we begin, let me remind you that these programs are one of the products of a strong association. If you are not yet a member and you're eligible, I urge you to go to the Alumni Association website and sign up. It's free. Okay, today's subject is the latest set of decisions by the U.S. Supreme Court, and I hope all of our participants have a strong stomach. The most remarkable decision of this last Supreme Court term was the decision that the wrong side won the Revolutionary War and that the United States would be better off with the king. But we won't be discussing that particular decision today. The court also made decisions of potentially great impact on EPA, all of them negative. This last year saw the demise of the Chevron doctrine, a negative ruling on the Good Neighbor rule under the Clean Air Act, a decision undermining administrative enforcement actions, and a decision that may allow untimely attacks on environmental regulations. Our panel, and I'm very proud to present this panel, is composed of William Buzbee. Bill Buzbee is professor of law at Georgetown University Law Center and is faculty director of the Georgetown Law Environmental Law and Policy Program. He's a prolific and well-regarded author in the field of environmental law and policy. Jon Cannon is Distinguished Professor of Law Emeritus at the University of Virginia Law School, served in a variety of positions at EPA, including General Counsel, Assistant Administrator for Administration and Resources Management, and Chief Financial Officer. Walter Mudgan recently retired from EPA Region 2 after 48 years of service. I guess you couldn't hang on for the 50, huh? At Region 2, he served as director of the Superfund office and as general counsel. And what was your most recent position, actually?
Deputy Regional Administrator.
You were Deputy Regional Administrator. Okay, so let us begin with Bill Buzbee, and we will start with you and talk about the decision on Chevron.
Oh, you're on mute.
Hi there. Yeah, I know. Sorry about that. So posted here is an outline of the comments that I'll offer. I'm going to be talking about a case called Loper-Bright. And this Loper-Bright case was a Supreme Court case from this past summer where the court explicitly overruled the famous Chevron case. That was the long prevalent framework for how courts should review agency interpretations of law. So here's what I'll do, just kind of all squeezed into about 10 minutes, I hope 10 or a few more minutes more. I'll just very briefly refresh your recollections that most of you probably know what the Chevron case was about, talk a little bit about the push to overrule Chevron and defenses of its long-standing framework. And then I'll talk to you about the ruling, what it's done, and then a little discussion of critique and questions about its application. I'll add also, although I'm focusing on Loper-Bright, the Supreme Court this past summer also decided a case called Corner Post, which we may all talk about a little bit. And just so you're aware, this case also works in conjunction with Loper-Bright. It is a case that has basically created a new ability of people to file challenges to regulations many years after they were finalized and possibly litigated. The Supreme Court basically has said entities that weren't in existence at the time of a challenge or a time of challengeability can later on challenge a regulation. So Loper-Bright has created a harsher environment for regulation, and Corner Post has allowed kind of new challenges years after things seem to be settled. So thanks. You can turn off my outline, so I'll just give comments now. So let me talk to you. So as you all probably recall from working at EPA, The law since the 1980s was that courts should defer to reasonable interpretations by agencies if the policies and their interpretations are permissible or reasonable. It had under a thing called the Chevron two-step. Basically, if there was a silence, a gap, or an ambiguity, the agency had some space to operate, and agencies typically have been found to have space to make numerous choices. And if so, Chevron said, courts should rely or defer to the more politically accountable choices of the political branches, namely Congress and agencies doing work. Over time, this was narrowed. So those principally, basically this only applies if an agency has been handed power to administer a statute, say EPA under the environmental laws, and when delegated power to act with the force of law, and this usually means promulgating regulations under notice and comment rulemaking, also applying to most things that EPA does, apart from enforcement and the like. This was very popular. The Chevron came out of the Reagan administration and was a rationale for allowing market-based regulation. But it became unpopular when people realized that it gave agencies newfound power to address new problems, and agencies use that range of discretion to address issues. So basically, it kind of freed up agencies to do more. But there was also a critique, which had some truth to it, that some judges sort of rubber-stamped agency actions and didn't really carefully look at statutes to see if agencies were acting within the powers that were conferred. And so I was at a conference or panel about a decade ago, more than a decade ago, at the Hoover Institution, and Senator Orrin Hatch came in and said, Chevron, we thought it would work for deregulation. It hasn't. We have to get it overruled. And that is what the Supreme Court did. There were defenses of Chevron. And so just quickly, one is Congress does delegate to expert agencies work that they have to do. And Chevron was basically rooted in this idea that courts should respect the congressional choice to allocate work to expert agencies. Also, agencies do know more about their statutes and fields than do generalist judges. And then also just statutes always leave questions unanswered. They're undefined terms or terms that need to be juggled. And so if there's discretionary choices to be made when the law runs out, that's the phrase used, better that it be agencies that have the first bite at the apple than courts, okay? Supreme Court relied on Chevron around 70 cases, lower courts, hundreds of cases. So one argument was just stick with this. This is a long-standing precedent that Congress has long understood, agencies have understood, and that is embedded within the law. So up to the Supreme Court goes the Loper-Bright case. And despite some immensely persuasive briefs, some of which I assisted with and many others, the Supreme Court explicitly overruled Chevron. It called Chevron illegal and contrary to the Administrative Procedure Act. It called it a husk, a dried up husk, moribund, that the Supreme Court hadn't relied on much. The court also said that the Chevron refinements had made it. I'm sorry, there was this words in the back by someone, but the Supreme Court described it as like filled with exceptions and complexity. Okay. And so some people have their mics on who may want to turn them off. In any event, and so the Supreme Court said, here's what courts need to do now. It said courts need to exercise their independent judgment, and they need to determine the best meaning of statutory provisions. And they said that repeatedly, like if there are refrains in the case that just come up again and again, it's judicial independent interpretive judgment and best meaning, including in several places the court says the single best meaning. The court also says that agency policy change is kind of a bad thing. you may, as some of you may recall, the Chevron case actually applauded agencies going back and refining and improving their policies. The Loper-Bright case clearly sees policy change as a problem and consistency as a good thing. In a few places, the court seems to talk about statutes needing to be read based on their original enactment time meaning, which would further limit them to the time of enactment. The court does say in the end, old rulings by courts should stand. That is, it's not overruling all cases on which Chevron was, or cases that relied on Chevron. So this all sounds like, utter demolition of Chevron. But here's where I think the game will be. So a lot of the game has to do with, okay, courts reading independent judgment, single best meaning. This will clearly empower judges to second guess agencies. Okay, but the court did have to deal with the reality of hundreds or thousands of statutes giving agencies power and telling agencies to, rely on their expertise to solve problems and sometimes work with broad language. So the court did, anyone who wants to look at it, the slip opinion, it's about page 16 to 18, I think, if you go to Supreme Court's website. The court said that in the end, so first, courts should still consider the body of experience and informed judgment of agencies. And it said also sometimes Congress confers discretionary power on agencies. And then it says expressly so. And it says agencies can be told to fill up the details. And sometimes agencies have to work with phrases that give an agency flexibility, like appropriate or reasonable. And so in those instances, the court says, then the court's role is to police the boundaries of the agency's power and make sure they exercise their discretion within the boundaries Congress delegates. So that's obviously a big exception to a case that seems to utterly demolish this idea of deference. So what has changed in critique? And then I'll call it, let's see how I am on time. How am I? Well, I don't know. Bruce, how am I doing on time? Well, I'll go on. I think, Bruce, you're muted, so if you gave me guidance on that. So what's changed? So the first thing is the mood of the case. If the previous mood was one of court should defer, this has the opposite sort of mood in its overall opinion. It is about judges are the architects of statutory interpretation. They are the main law interpreters, and agencies need to basically meet with agreement from courts who have to police what agencies do. Okay. This case also seems to say claims of discretion by agencies need to be rooted in explicit delegations of such power. Chevron said implicit delegations are good. Chevron, as I said, applauded agency policy refinements and change. Loper-Bright says that's a bad thing. The single best meaning language is really a problem, since agencies, if you think about it, all agencies acting under all statutes, when they act, they're always doing something new. Okay. So the whole idea that there's a single best meaning disfavors any new regulatory policy any agency could issue. As far as a critique, I'll save it some for our discussion.
Yeah.
The whole case is kind of founded on a category mistake. The court keeps talking about regulatory statutes as about meaning. As all of you know, what agencies read statutes for is what they need to do. That is, the agencies are charged with doing of things, of making choices and dealing with problems. And so the court's whole framework is this is about reading and finding meaning. And if they instead thought about agencies needing to act and usually juggle many factors, that it would have been a much clearer opinion. The court basically defines away the very problem that Chevron was dealing with.
Bill?
Yes.
Let's kind of wrap up, and then we'll come back to this.
Excellent.
We'll leave plenty of time.
Thank you. Excellent. So I guess I'll just close and say this, that, a question that those of you still doing environmental law would have is, what's going to happen as a result of this? Okay. Anti-regulatory interests are going to have a field day. That's already happening. Agencies are going to be scared. That's already happening. Agencies will say choices are much more about evidence and facts, filling up the details. And the other thing is something the court doesn't consider. Agencies that used to think elucidation and clarification of statutes was a good thing, no agency is going to voluntarily engage in legal clarification in the form of interpretation. They're opening themselves up to judicial rejection. So agencies will do things and not explain things as much. And I'll pause there and leave it to others, and happy to answer questions. So thank you.
All right, we'll hold questions till the end. Unless any of the other panelists want to add a quick comment or two, let's move on to Jon, and let's talk about what the court did specifically to the Clean Air Act.
Okay. So is that the slides up?
Yes, it's up.
Great. I'm going to talk about Ohio EPA, which is a much less consequential case than Bill just discussed in Loper Bright. It's a little muddled, and I think the final resolution is far from clear, but it does suggest some inclinations by the court that go beyond simply limiting the discretion of agencies in interpreting statutes. I think it may suggest that the court is also going to be much more demanding about agency compliance with standard administrative law requirements, procedural requirements, and maybe even technical deliberations on the record. So Ohio EPA, the EPA, is a case in which the court stayed EPA's 2023 Good Neighbor Plan under the Clean Air Act. It represents an unusual move by the court, granting a stay while the case was still pending before the lower court, the DC Circuit. So the majority of the court in this case moved to stifle an agency rulemaking before it had been decided on the merits below. That has a preemptive character similar to West Virginia v. EPA, but here the court's animus is directed not toward agency interpretation, which is the particular province of the court, at least as the court stated it in Loper Bright, but against the agency's compliance with administrative procedures. So what was the case about? It was the Good Neighbor Plan. It was a plan in the form of a federal implementation plan applicable to 23 states. It followed the agency's revision of the ozone NAAQS in 2015, which triggered a requirement that states upgrade their state implementation plans, including their compliance with the Good Neighbor provisions of the Clean Air Act. The agency found that 23 states failed to submit adequate SIPs in that process, including failure to comply with the Good Neighbor provisions. And these were states that contributed 1% or more to ozone levels in downwind states that were in or expected to be in non-attainment. And you can see these states, these are the crosshatched dark blue states here, plus Alabama, plus California. The agency then issued a federal implementation plan that applied what the agency believed were cost-effective controls on sources in these upwind states. Those controls focused particularly on emissions of nitrous oxides, an important ozone precursor. This construction of the SIP, this creation of the FIP was very like the creation of the earlier ozone transport rule that was upheld by the Supreme Court in EME Homer. This particular outing by the agency fared less well before the court. So there's a history to the litigation, a little bit complicated, but I think it's important to understand in understanding how the case arrived at the court and what the court's concerns were. So a lot of the states, or a number of the states covered by this plan, went to their circuit court and argued that the EPA's rejection of their SIP was invalid. And in some of those cases, by the time this litigation came before the court, in some of those cases, those circuit courts had issued a stay of those SIP denials, making the FIP inapplicable in those states. And that happened in about 12 states. Meanwhile, petitioners saw a review of the plan itself, the Good Neighbor Plan, in the DC Circuit, where reviews of this kind are required to be brought. The DC Circuit denied a stay, still in the process of considering the case on the merits. And the Supreme Court, in this unusual move, considered petitions for a stay directed to it and decided to grant the stay in June of this year with a written opinion. In deciding that the stay should issue, the court balanced harms and equities on both sides, issue stay, not issue stay, found they were more or less offsetting. It focused on the merits and whether the rule was likely to be reversed on the merits when it came to be finally decided. And it decided that the FIP was likely to be invalidated and therefore issued the stay. The analysis of the court focused on it was premised on the notion that the FIP was based on an analysis assuming a 23 state assemblage, and that the agency failed to address consequences for the FIP if fewer than 23 states ended up being covered. And that was a possibility, the court said, because all these states had been successful in getting stays, at least, of the FIP as applied to them in the dispersed circuit court litigation. What the court particularly focused on was the potential of a reduction in the number of states covered by the FIP to affect the cost effectiveness calculations that EPA had used in setting the budgets for each of the states. The court says that issue was raised fairly in comments on the rule, on the proposed rule. EPA failed adequately to respond to those comments. In so doing, it ignored an important issue, and that was a reversible error. Now, interestingly, between the argument on the stay and the decision, argument in February, decision issued in June, EPA issued a partial denial of petitions for reconsideration of the FIP that had been lodged with it. And in that partial denial of these petitions, it stated clearly that its denial, that its analysis for any of the states covered by the SIP or by the FIP was not affected by the inclusion or exclusion of other states. That is, the cost-effective controls were determined based on national data, and therefore, whether one state or another was included wouldn't affect the controls applicable to the remaining states. The court gave no consideration to that because it was not in the record before it, but the dissent made a big deal of that, as you might expect, as making clear that the factual concern that the court, was animating the court was really not a valid one. The dissent, and this is interesting, it was a 5-4 decision, dissent issued by Justice Barrett, who doesn't usually align in this way, but she argued vigorously that EPA was not going to fail on the merits, no SIP denial had been actually invalidated by the time this decision was issued. More importantly, she found that there was no evidence that the FIP limits would be different if less than 23 states were covered. And she sought to draw from the record before the court, that the EPA's cost effectiveness determination had been based on national data and would not be affected by the number of states actually covered by the FIP. And finally, she argued that the commenters had failed to raise the issue that the court made such a deal of with reasonable specificity. They had talked about consequences of having less than 23 states for the FIP, but hadn't really elaborated on that. And the court really was the one supplying the specificity that would be necessary to make the case against EPA. So what to make of all this? It's kind of a hodgepodge. And in the aftermath of the court's decision, back in the DC Circuit, EPA asked for a remand of the record so it could supplement the record for purposes of further review by the court, and that was granted by the DC Circuit. So it's possible, I'm not quite sure how this would work, but it's possible that EPA could add to the record what it's already said in its denial of the petitions for reconsideration and clarify the whole issue and make it go away. But what does the court's posture here mean? And I've just raised these issues for further consideration. I won't try to deal with them elaborately, but there was a tension here between different competing statutory purposes and policies. Is the main policy of the Clean Air Act to make sure that EPA doesn't overregulate? Or is the main policy of the Clean Air Act to make sure it doesn't underregulate? You would get competing views of this if you read this decision against EME Homer, Justice Ginsburg's decision in that case. What about deference to the agency? Bill talked about deference to agency legal interpretations. What about deference to agency administrative processes and factual determinations? This case gets right into the heart of what agencies do. And here the court is taking a very strict posture of oversight with regard to the agency's compliance with notice and comment procedures and failing to consider or failing to grant harmless error as the dissent urged. And then finally, deference to states. Here the court places a lot of emphasis on the importance, the primacy of the states in the SIP process, the flexibility they need, and contrasting that, at least implicitly, with the sort of centralized approach of EPA. Whereas, as is emphasized in the dissent, we have a major interstate externality problem here that needs some sort of centralized control. How do those two considerations balance out, and how is the court positioning itself with respect to them here? So that's all I'll say now, but happy to talk further as we go.
And that case has also proved to be somewhat difficult. And the question is whether it's the death knell for administrative enforcement. I'm going to see if I can advance these slides. So a little background, in several years during the early part of the 20th century, Congress passed a series of laws regulating the trading of securities and the activities of investment advisors. And these are in their totality, they're called the anti-fraud provisions. And they all, target the same sort of behaviors, and Congress created the SEC specifically to enforce these laws. And Congress gave the SEC enforcement authorities very similar to those that EPA has under most of our statutes. It could either file a suit in federal court or it could adjudicate the matter itself, and that's called administrative enforcement. And of course, EPA does that all the time. And Congress originally said, well, the SEC could only obtain fines or civil penalties if it went route of going to court through judicial enforcement. But in 2010, the Wall Street Reform Act authorized the SEC to impose civil penalties through administrative enforcement actions. And again, most of EPA's statutes give EPA that same sort of authority. So let's talk a little bit about the distinction. And the court cited these distinctions between judicial and administrative enforcement. If you're in court, there's a jury that finds the facts. There's an Article 3, constitutional Article 3 judge, which means they have a lifetime appointment, can't be fired, who presides. The federal rules of evidence apply and the ordinary rules of discovery apply. But if you're in the administrative forum, there's no jury. In this case, the commission, the SEC itself, presides. Same is true for EPA. There's a division of enforcement within SEC that prosecutes the case, just like there are enforcement offices within EPA that prosecute these cases. And either the commission itself or a delegee, like an administrative law judge, an ALJ, typically finds the facts, decides the discovery disputes and so forth, and determines or recommends the penalty. And the SEC itself has rules of practice that govern it rather than federal rules of evidence. Background of the case itself is that soon after the 2010 law that gave SEC the administrative penalty authority, the SEC brought an action against this guy Jarkissi and his firm and said, hey, you were violating the anti-fraud provisions, and they levied a fine of $300,000 against him. He appealed it to the Fifth Circuit Court of Appeals, which vacated the SEC order on the ground that adjudicating the matter in-house, meaning within the SEC's four walls, violated the defendant's Seventh Amendment right to a jury trial. So the SEC appealed that up to the Supreme Court, and in June, a fateful month for administrative law decisions, SEC says, the court says, when the SEC seeks civil penalties against a defendant for securities fraud, the Seventh Amendment entitles the defendant to a jury trial. So that's where it starts. So those of you who may not remember your constitutional law, what does the Seventh Amendment says? It says, in suits at common law, where the value in controversy shall exceed $20, maybe there was a time when that was a lot of money, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the U.S. than according to the rules of the common law. So basically, it's a little bit, the syntax is difficult to understand, but basically you got a jury, and only in accordance with the common law can any court change what the jury had to say or adjust it. So the Supreme Court goes on to say, well, this action implicates the Seventh Amendment because the SEC's anti-fraud provisions, which were at the case here, they replicate common law and a common law fraud, which has existed. Now, common law, for those of you who aren't lawyers, is the accumulated legal decisions made by courts and judges over many, many hundreds of years of Anglo-American jurisprudence. And it's not, common law doesn't usually talk about rules and regulations that were issued by the king or by the Congress since our democracy was established. It really talks about laws made by the courts, and it's common because it's just common to all of us. The Supreme Court goes on to say, well, there is this public rights exception that we've carved into the Seventh Amendment, but it doesn't apply here. We'll explain in a moment why not. So the Supreme Court goes on to say, you know, this Seventh Amendment right is really super important. It's got this central place in American history. It was one of the real reasons why we had a revolution altogether. And in the revolution's aftermath, concerns that the Constitution didn't really embody this right was one of the major and most successful arguments for having the Bill of Rights. Those 10 rights that were established in the original Bill of Rights, the Seventh Amendment being the one in question here. Supreme Court goes on and on to talk about the common law, and they said, by the way, this decision, this Jarkissi decision that we've just now written, it's not limited to common law forms of action recognized when the Seventh Amendment was ratified. Way back when the Seventh Amendment was ratified in the end of the 1700s, there were certain kinds of infractions that were understood to exist under the common law, but this decision isn't limited to those. Because no, it's limited, it's embracing all suits which aren't of equity or admiralty jurisdiction. Now, those were two other kinds of jurisdiction that existed in British Anglo-American jurisprudence. basically lawyers talk about cases at law and cases in equity. And it's the cases at law that the court says are really subject to the Seventh Amendment here. And this last paragraph says it's the remedy that the agency is seeking that really is dispositive to determine whether this is a legal case or an equitable case. If the alleged, in this case, the SEC was seeking civil penalties, and that's a form of monetary relief. Just like if you slip on someone's sidewalk and you sue them or they sue you, they're looking for money. That's monetary relief. That's a legal cause of action, and that's designed to punish or deter the wrongdoer. Maybe the example I gave you was not a good one, because in that case, you're supposed to restore the status quo by giving the person their medical expenses. But if the person then also seeks some kind of damages for your negligence, that might be a more comparable example. But in any case, the court says, if the primary purpose of the penalties is to punish or deter, rather than to restore the status quo, then it's the Seventh Amendment. And the court says, you know, these civil penalties, according to the SEC, under the law that the SEC administers, are supposed to consider things like culpability. It's supposed to generate deterrence, to deter other people from violating law. And it's supposed to deter recidivism, people violating again and again. And he said, those factors go beyond restoring the status quo. They really are more legal in nature. So it's the Seventh Amendment that is active here. So what's the EPA? What's the impact on EPA enforcement? Well, as I said, most of our statutes, most of EPA's statutes authorize administrative enforcement, and most include the authority to impose civil penalties. Now, some of them may be similar to common law infractions like trespass. Your pollution trespasses onto my property, or nuisance. Your pollution creates a nuisance to me. Or negligence. You negligently disposed of your hazardous substances and it harms me. But others do not have a common law analog, maybe, I don't know, permitting or record keeping or reporting violations. But as I said a moment ago, the Supreme Court decision downplays the relevance of common law antecedents and instead emphasizes what's the nature of the remedy that the agency is seeking. If the remedy is money and it's intended to deter, then it's legal in nature and the Seventh Amendment applies. That's distinct from injunctive relief. In injunctive relief, the agency, the plaintiff, the agency is trying to say, stop doing something wrong and or start doing something right. That is equitable in nature. That's injunctive relief. That is not subject to this Seventh Amendment jarczy decision. However, EPA penalty policies, of which there are many, typically do consider factors similar to those that were identified by the Supreme Court: culpability, deterrence, recidivism, in setting what's called the gravity component of EPA administrative penalties. EPA also has something called an economic benefit component. But looking at the gravity component, which is how serious was the violation, how bad is it, there, my assessment is that those kind of actions are probably subject to the jarczy reasoning. And if the violator wants to have a jury trial in court, they're entitled to it under this decision. EPA also has this thing called the economic benefit component of penalty, and that is designed explicitly to level the playing field, to restore the status quo, to make a violator, to remove the economic benefit that a violator enjoys compared to their compliant competitor. Maybe the economic benefit components are not subject to jarczy because they're intended to return the status quo. That'll be seen in years to come. I submit that administrative compliance orders by EPA are injunctive in nature and therefore presumably are not subject to jarczy, and so EPA should be able to continue to do that. As the Supreme Court said, there's this public rights exception. It goes on, but it really doesn't apply to the kinds of cases that EPA brings. So I don't think we need to spend any time talking about it. The one exception might be that supplemental environmental projects, or SEPs, which EPA sometimes allows as to a way to lower the penalty in exchange for doing something that the law doesn't require, but that's environmentally beneficial. That could be considered a way to compensate victims. Maybe that can escape jarczy adjudication. I submit, however, that altogether the decision is not the death knell for EPA administrative penalty actions. EPA will continue to proceed with administrative enforcement, including the proposal of administrative penalties. If the respondent says, hey, wait a moment, I want my jury trial, EPA can withdraw the administrative action and refer the matter to DOJ. However, for most respondents, it's typically cheaper, it's faster, it's much lower profile to resolve the matter administratively. So many of them may say, well, all right, let's handle this administratively. And EPA could even incentivize this by saying, all right, if you want to settle a case administratively, we'll give you a better deal. If you want to go to court, fine, we'll see you in court, but we're going to be asking for much more money there. And if the defendant decides to accept the administrative settlement offer, that document will likely require an explicit waiver of the right to a jury trial. And that waiver should even cover stipulated penalties. That is, these are penalties built in for subsequent violations of the administrative order and for dispute resolution. Even if the respondent declines to settle the penalty liability, a respondent could conceivably say, let's go to an administrative hearing on liability. Am I liable or not? And on the injunctive relief that you, EPA, want. I don't know whether it would be in EPA's interest to agree to this or whether the ALJs would accept such a restriction, but it's something that we'll have to see how it plays out in the years to come. Now, it's important that we consider the DOJ factor. DOJ has limited resources. Even pre-JARCAC, they were stretched. But in order to provide these incentives for the violators to continue to settle administratively, DOJ really has to be prepared to accept EPA referrals when a respondent invokes JARCAC. They got to be prepared to litigate the cases before a jury if absolutely necessary, and they should not offer settlement on terms equally favorable or, God forbid, even more favorable than those offered by EPA in the administrative context. Finally, I suggest that alleged environmental violators may conclude that a jury trial is for them the least desirable forum, that a jury of 12 citizens are not going to be sympathetic to many of the kinds of violations that EPA tends to prosecute. So we'll see how this plays out. But it was another element in the interesting June decisions from the Supreme Court.
Thank you, Walter. I got to add one comment, which is, if you look at the environmental statutes, the conceivable maximum penalty in a lot of cases is enormous. I mean, when I used to do cases, there were times when we didn't even mention what the maximum penalty was because the number was so ridiculously high. So, this is going to take some interesting thought on EPA's part how to play. But if you put yourself in the hands of a jury that can assess $25,000 per day per violation,
and we're up to 37,000 or something like that on most because of inflation.
Oh, okay. Well, that's a risk. That's a big risk.
Yeah, it's a big risk.
Okay, I want to turn back to Bill Buzbee for a moment because you didn't have time to talk about corner post and its effect on the timeliness of challenges to agency rules. And I think that deserves some discussion.
So sure, and until we allow time for questions, I'll just briefly give a little more detail from what I started with, which is so the Supreme Court in Loper Bright overruled Chevron deference and clearly has given challengers in courts much greater power to second guess agency statutory interpretations. So more regulations are challengeable is the bottom line. The corner post case was the case where the Supreme Court unexpectedly basically jettisoned the presumptive statutory 6-year statute of limitations for challenges to regulatory actions, and maybe others too, we're not sure in the court's ruling, but basically said an entity that is not in existence at the time of a regulatory action and time for challenge, later on, if they're affected by it or challenged, I suppose, they can bring a challenge. So if you actually look at corner post, a good corporate lawyer can create a new entity, and if the new entity is affected by some regulation and they don't like it, they probably can bring a challenge even if it's many, many years old. And so when you put Loper Bright together with corner post, the effect is that many more regulations will be challengeable. So even if a regulation seems to be finalized and have been reviewed under Chevron and the like, someone now could bring it up and challenge it anew. And then also, I'll just say, in addition to corner post, what are people going to do? there's a general petition option under the Administrative Procedure Act and some environmental laws as too. So people who don't like a regulation will try to kind of restart the regulatory process with petitions and try to use Loper Bright.
Hey, well, thank you. I'm looking in the chat and there are no questions. I think what we've done is stunned our audience. And everybody needs to take a breath and think about if they have questions. My question, which I'll take the opportunity to ask. I mean, the big question here is, where do we go from here? I mean, we've had a couple of cases where the court has reached to find a case that it didn't need to take. As John pointed out, that was true in the Good Neighbor Policy ruling, but it was also true in Sackett, where they could have avoided taking that case very easily. And they reached out and took it. So this court's, we'll use the word animus towards environmental regulation is very strong. So where do we go from here? And let's be specific. We know that the climate rule is going to come back to the Supreme Court, almost certainly. What do we expect?
Well, I could say something that I can say it's even worse than we're saying. So, so just to really make everyone despair is I've been looking at a lot of these big regulatory decisions, including the environmental decisions, and a cross current along all of them, including the Ohio versus EPA, is this Supreme Court doesn't seem to view itself as being wedded to the actual facts of a case and the actual record. In almost all these cases, they'll make assertions about actions and effects and risks that have not been established. Sometimes are not in the record at all, including the West Virginia versus EPA, the major questions decision. And so if you think about, if sort of what I'm in this article I'm working on, I call conjectural harm. So conjectural regulatory review. So the court is second guessing, meaning fly-specking statutes and regulatory actions and the Ohio versus EPA decision, but then also sort of making up facts like the Sackett case, the big Clean Water Act case. If you look at the decision, they basically sidestep the actual facts of that case to talk generally about their concerns with wetlands protection and really didn't grapple with the record in that particular action or past rulemakings. And so it's the combination of all these legal developments is really problematic for any protective regulation and any protective regulatory scheme.
And Bruce, I don't think it's all that surprising. I think that for decades, the conservative elements who have been promoting certain judges for consideration to appointment to the courts have specifically targeted what they call the deep state, the administrative state, as being something that they want to rein in and limit. So these are examples of exactly that. And as Bill says, if there are more opportunities, which there will be, they'll go further. In fact, you had posed a question earlier when we were speaking among ourselves, is why didn't the court go further? The court could have reached into some OSHA case and said, let's take that case up and get rid of the entire concept of, can Congress delegate to administrative agencies the authority to do all this stuff? And the court didn't do that, or hasn't done it yet. But that's a fair question as well that maybe my colleagues have some thoughts about. And there are some questions in the chat that we can get to as well.
Yeah, well, I want to get to the questions in the chat in a second. Any more comments on this general issue?
I really like Bill's comment on the sort of the generification, if that's a word, of these parties. What the court is seeing is the boogeymen that, they've been waiting to see and wanting to knock down. So, I mean, you see that in the rhetoric in the Sackett case. It's just like the poor, burdened landowner overwhelmed by the large, impersonal bureaucracy that has no care for their well-being or flourishing. And it's almost a caricature of what it is a caricature of the diversity of the reality out there.
Yeah. And actually, I'll add it, like in the Sackett case, the court goes on and claims this is just no one can possibly know their status. And actually, so first, those of you out there who worked on 404, there's no shortage of law giving people guidance under 404 and what kinds of things are protected. And actually, in the Sackett's case, their own consultant came in and said, yeah, this is a wetland. And then miraculously, perhaps regulators did go to the site and they said, yeah, this is in fact a wetland. This is protected. And also the map showed it as a wetland or part of a wetland complex. And so they had actually explicit notice and they knew exactly what, but the court ignores that, right? And as Jon says, they go on saying, how can anyone know? What a burden, what a mystery. And so I see, by the way, in the discussion, someone asked about implicit delegations versus explicit delegations. So Bruce, can I just give a very quick answer to that?
Yes, please.
Okay,
Please.
so under the Chevron case, the previous framework for deferential review of agencies, the court said it doesn't matter if an agency is implicitly dealing with a delegation of authority or explicitly, because agencies are handed turfs and then there's just, you know, terms that aren't defined in the rest. And the court said it doesn't matter, you know, agencies know more, they're more accountable. The Loper-Bright decision critically mentions the idea of implicit delegations, and in its saying there still might be discretion and deference, it talks about when the agency is expressly given power. So putting it all together, I think this court is saying agencies claiming discretionary power have to really show an express delegation of power to do work where deference would be due. And so that's a very big change.
There's a question, does jerkacy have any impact on state administrative actions?
I would say in the first instance, it depends on what the state constitution provides, whether if the state constitution provides a similar right to a jury trial in civil cases or civil penalty cases or things of that sort, then arguably yes, or very likely yes. The same reasoning that the court applied in jerkacy might likely be applied by the state court. I don't think that jerkacy decision, the Supreme Court decision, would directly have an impact on state administrative penalty authorities, but if either Bill or Jon think otherwise, they can correct me.
That sounds right to me.
Yeah, I guess I think everything that everyone said about the cases are spot on. So, and the only thing I would just add about, for those who, you know, jerkacy seems maybe a little obscure because you're probably, people who took administrative law said, why was there a question here? And the only thing I'd add is that for the past 40 years, there was a case called Atlas Roofing that answered this question. And so the view had been, if Congress hands a task to an agency to adjudicate internally, there is no jury right. And so it was most of us teaching administrative law spent 10 or 15 minutes on this issue. And so the Supreme Court doesn't say it's overruling Atlas Roofing, but it shrunk it down to, you know, a tiny, tiny sliver of it. So this is just another instance where the courts kind of claims like, oh, this is all so clear, but this is a revolution. I mean, this is a court that doesn't see precedence as mattering much and is, I guess, as Jon was saying, you know, whatever, they're eager to jump into the fray, and they have.
Another question, someone asked, the major questions doctrine, does the new major questions doctrine affect administrative practice?
Yeah.
And
Jon,
then
you want to go, Jon, since I've been speaking? So
yeah, it does affect administrative practice. Obviously, I mean, I remember being at the agency, we were always talking about, well, what would, with respect to the Clean Air Act, for example, which has a lot of ambiguous provisions in it, we were always talking about, well, how far can we go? What's reasonable? And now the game has to be different. It has to guess what the court's going to come up with or accept as the real meaning, which of course can't be determined, but you'd have to make some sort of projection about that. I think, you know, Loper Bright, in a way, kind of overshadows now the major questions doctrine, because it seems to say that that's going to happen for every case, not just for cases where the, you know, where the agency may be pushing the envelope in terms of impactful socioeconomic, but for everything. And, you know, that there's an heroic assumption buried in that opinion that the court, that there is actually one real discernible meaning that the court is uniquely equipped to find. And that is so implausible to me as to be a fiction. But if that's the fiction that the court must indulge, then so be it.
Yeah.
Quick question. Does anybody know if anybody's tracking whether there's been a big uptick in challenges to, let's say, EPA rules?
Oh,
Because certainly the door has been swung wide open in a lot of ways.
I don't know about EPA rules. And Bloomberg in this press had an article about challenges relying on Loper Bright just a few weeks ago. And I think it said there are already 38 reported decisions applying Loper Bright, and 25 out of 38 rejected the agency's view of the statute. So if agencies used to win in regulatory challenges based on everything about 70% of the time, Trump administration lost 95%. But put aside the Trump administration, in ordinary times, agencies usually win. You know, in this case, so to have 25 of 38 rejecting an agency's statutory interpretation, that just shows you how much it's empowered judicial second guessing.
I would ask, how many of those
and interestingly and bizarrely, the Department of Defense, the Air Force, has challenged EPA's PFAS drinking water rule. So there's a situation down in either Arizona or New Mexico where there's an Air Force facility that has created PFAS contamination of the drinking water. EPA has this drinking water rule that says, hey, you got to remedy if it's over whatever it is, 4 parts per trillion or something like that. And DOD, the Air Force specifically, has written essentially a brief back to EPA saying, no, you can't do this under Loper Bright. Courts shouldn't defer to this, and this is not the right thing to do. Of course, one agency can't make that kind of an argument to another one. And it's all very, very bizarre. It's also bizarre that the executive branch of the US government is allowing this to happen, but these challenges are all over the place right now.
I'm going to make a prediction, which is if EPA rule like the climate rule comes back, there are 3 possible outcomes, of course. The court takes the case and overrules, which is pretty likely. The other is that the court takes the case and upholds the rule. And the third is the court doesn't take the case. So my prediction is if the court ever finds a rule that it just can't find a fault with, it will simply refuse to take the case. Because I just do not see this court upholding an environmental rule.
I think you're right. I think it's a one-way ratchet right now.
Yeah. The one thing I'd say, just there's a question on the side about, agencies' power to address climate. I know this is the EPA Alumni Association, so but the Inflation Reduction Act quite explicitly in numerous provisions has handed not just EPA, but lots of agencies powers to address climate change. And so I do think that that's going to change the complexion of legal challenges over climate, because it's a statute that's several hundred pages long on climate, and provision after provision is seeking action to address climate. It redefines, it makes clear greenhouse gases are subject to regulation under the Clean Air Act. And so, so climate in particular, a challenge like Massachusetts versus EPA, where people said EPA has no power to address climate. I think that's those kinds of arguments will fail. What I think is a risk is some particular provision. Can EPA do some particular thing, and then like in Ohio versus EPA, looking for some tiny little comment buried deep within thousands or millions of comments, and then claiming EPA has failed to address it. That may be the sorts of challenges we'll see after these cases.
I think one advantage of the Inflation Reduction Act is that a lot of the mechanisms used in that act are tax mechanisms or grant mechanisms, which are different from regulatory mechanisms, and the court may be less likely to want to tie into those. It seems to me it's not the regulatory boogeyman that the court seems to have in its sights. We'll see, but I think that may be an additional strength of the Inflation Reduction Act, at least vis-a-vis exposure to judicial review.
Well, we've talked about this before in a prior presentation, which is, does the Inflation Reduction Act signal in some important way a new way of doing business? That in addition to being perhaps less prone to court challenge, might really change in important ways how EPA sees its role?
I think the answer is yes. The whole reason that the IRA was written the way it was because that's giving out money and giving out incentives of that sort is something that's simply less politically undesirable than regulating. Ultimately, if there were ever to be any kind of political will to really go further on climate change and to give an even bigger incentive to industry, to the American economy, the way to do that might be to simply impose a tax on carbon. And maybe that would also be a little less prone to, if Congress did it, it would be obviously Congress doing it, and the agencies would simply be administering the tax code. I don't know that there'll ever be any political will to do that, but it does indicate that that might be a better way to incentivize the reduction of greenhouse gas emissions by putting an ever increasing price on carbon over time.
Yeah. I want to add one thing for those who may be studying law now or working EPA and not alums yet, is the EPA and everyone working in regulation saw something like Loper Bright coming down the pike. And after the major questions doctrine in West Virginia versus EPA, people saw the court was going to be skeptical. And so if you look at EPA's regulations from the Biden administration, they are all drafted anticipating kind of where the law has gone. And so there's much less reliance on language and much more just saying, okay, we're told to look at the best that's being done. Here's the best plants in this place. Here's the best plant. And so making really clear that these are factual, actually real case based regulations. And so this is a way to try to insulate them from rejection. So already basically less about words and more about obeying the statute, but going out there and observing, seeing what is happening. And so people, bottom line is EPA is regulating differently and with greater care just because it needs to, and other agencies are as well.
There's an interesting question in the chat.
I'm just going to make a quick comment, and then we'll get back to that question. For those of us who were present at or very near the beginning, if these cases had come down then, we never would have launched. It just never would have gotten off the ground. Anyway, how would these actions, here's from the chat function, how would these, I'm going to say, decisions impact the citizen suit provisions of the environmental statutes?
Well, I don't think it would change the provisions, but I do think citizen suits now of those who dislike regulations are going to be looking for any single error by agencies under statutes, like anything that is, and then looking at the Ohio EPA, looking for any agency failure to address an important salient comment. And so citizen suit provisions will be more powerfully wielded by opponents of regulation. I don't think there's going to be a change in their interpretation, but I think they'll be used more aggressively.
What about proponents? I mean, that citizen supervisions drove an awful lot of EPA rulemaking back in the day.
Mhm.
What happens to those?
Well,
Depends if there's an administration that ends up being hostile to environmental regulation or trying to draw it further back. Presumably the same kind of arguments can be made that if the agency doesn't have a solid record, that the agency is not entitled to deference from the courts in those kind of retrenchment decisions. But the real question is, will the courts ultimately side?
Right.
Who will the courts ultimately side with? EPA usually gets sued on any major regulation by both sides, by those who say it's too far and those who say it's not far enough. And so the court has to ultimately decide which of those two it's gonna side with. And I think we can probably guess where the current Supreme Court would side. There's also citizen suits for specific enforcement. That is, there are citizen suits against the agency for either going too far and not going far enough on a regulation, or not doing it at all. And then there are citizen suits against violators saying, hey, you're in violation of this rule. EPA hasn't come after you yet, but we're coming after you. And we want injunctive relief and we want penalties. Presumably they can get the injunctive relief without, I mean, presumably those cases are brought judicially in the first place. So the Seventh Amendment argument doesn't apply there. They're brought in court. If the defendant wishes to have a jury trial, they can have a jury trial. So I don't think the Jarkissi decision will affect citizen suit enforcement actions. The Loper-Bright decision and the corner post decision about when you can file cases, that may have some impact. I don't know. Yeah. Certainly it'll have impact against, as Professor Buzbee said, you can create a new steel company, create a new car company, and suddenly file suit against EPA for regulations that were written 10 years ago.
I think there's no more questions in the audience. I think folks are wanting to maybe have a stiff drink at this point. Does the panel have anything they would like to, are there any glimmers of hope we can offer, or any predictions about what may happen next? What's the next term shaping up to be? Do we have any sense yet?
I've heard that the people are trying to queue up a delegation doctrine challenge, which would be a further limitation on Congress's ability to hand agencies meaningful discretionary power. The view had been recent years that between the delegation doctrine, between the major questions doctrine and Loper-Bright, it might have taken the steam out of this push to further imperil the administrative state. But there is apparently a case that is being pulled together now. I'm not sure that just a friend at the Supreme Court Institute here said, oh, the Solicitor General is going to probably have to file. And this is a case that may end up being the vehicle for the court yet again to look, for anyone who's trying to remember, no one in this room or in this Zoom room was alive when the Supreme Court last struck down a statute for violating the non-delegation doctrine. But this court, there is a majority on the current court that has said they're willing to at least revive it some. They just haven't found the case yet. So
not even Scalia was willing to go there, and
yeah,
now we're there.
Yeah.
Well, I think more than just Scalia, I think it was more than just Scalia actually has mulled over this question. But what always strikes me is if you're going to strike down what EPA does under that doctrine, you're also going to strike down what the FDA does.
Yeah.
And the FAA, no more airworthiness directives. I mean, really?
Yeah.
So the Fifth Circuit decision on the Jarkissi case actually had additional elements, not just the Seventh Amendment, that they had additional reasons for saying that the SEC didn't have the authority to issue these penalties, or that Jarkissi had a right to a jury trial. The Supreme Court didn't pick up on those other bases that the Fifth Circuit had cited. So it's an interesting choice that the Supreme Court made not to go further. For example, there were delegation issues. Question is, administrative law judges, if they if they can be, I don't know, hired and fired by the executive of the agency, then that's not appropriate. So there are other issues there that the court didn't choose to follow up on. So. But maybe they will again in another matter. That's fine.
Yeah, I was gonna say 2 silver linings for people working in environmental law, just for a touch of optimism. Okay, so most of the environmental law statutes are just filled with quite detailed instructions. And so I don't think many, if any, of the big environmental laws are the ones that will be very vulnerable to a delegation doctrine attack. I just, except for the enmity of the current Supreme Court to environmental law. So that's one thing. And the other is environmental laws have one important aspect that may make them survive a lot of this, which is, all over the environmental laws, there's best based BAT-based regulation, where whether it's a permit or a regulation, there's a sort of benchmarking of the best and setting limitations. And that is quite clearly under all this law, that's a kind of a constraining task, and it's also a fact-based task. And so I think EPA and other risk agencies that work under similar statutes, if they're really careful to make clear they're trying to determine the best and point to real things, and are careful to do so, I don't think all is lost for environmental law. So that basic mode of regulation that's all over the environmental laws insulates them a little bit from kind of total demolition by the current demolition crew.
Well, it's one other factor too, which is I'll call it the big company versus the small company factor, which is if you have a large company that values its public reputation, it actually would face a competitive disadvantage if smaller companies are getting basically away with not doing a lot of obligations. So you wonder whether there comes a point at which the very large corporations weigh in and say, we actually want some of this regulatory structure to survive.
That supposes that politically people pursue their self-interest in a rational way, which current political thinking questions that, at least as to individuals, maybe not as to corporations.
Yeah, and actually, there I was trying to be optimistic, but in 2021, 2022, in the big West Virginia case that led to the major questions doctrine, the power companies strongly aligned in support of EPA's regulation. Mm-hmm. And they argued before the court, and in their briefs, they said this case is based on hypothetical worst cases that don't exist. And they made this argument to the Supreme Court saying, there's nothing in the record to say this is a shocking regulation. This is business as usual. Right. And the court just ignored it. It just ignored it. So I think this is an instance where you had the directly regulated sector explicitly said to the court, this is no big deal. Don't listen to people yelling and screaming from coal states, which is what it was. And the court just nonetheless went the way it did. So unfortunately,
fact-free jurisprudence, right, Bill?
Excuse me?
Fact-free jurisprudence.
I think the rule, although it had been stayed, had actually been achieved, right, in terms of the reductions that it contemplated, simply by the operation of the market. So hard to paint it as a draconian intervention by a regulatory agency. Anyway, I will say that in the future, as to the future of environmental law, I mean, who knows what the court will do, but I think EPA is a wonderfully resilient, creative, and resourceful institution, and will continue to be so. And it will continue, as Bill suggests, to find effective ways to do what it's mandated to do. That's as hopeful as I can be.
All right. Any other final comments at this point?
No, just thank you to Bruce and Beth for pulling this together, and also the co-panelists, both of whom in my own past research and work have been immensely helpful in helping educate me about environmental law. So it's a real pleasure to be on the panel with them.
Well, thank you. This was excellent presentations all around. Are we going? Question for who's on for the front office here? Is anybody on in terms of setting up a breakout? Anyway, I will thank the panel and wish you a very good evening. And if we're not going to have a breakout, I thank all of the audience for your
Yeah.
kind attention.
Thank you.
Thank you
Thanks.
very much.
It was a
And
pleasure.
thanks, everyone. And,
Yeah.
and good luck in your work.
Take care.
Bye.
Bye.
Bye.